I don't want to be hard on Conway Twitty. He was a great man in many ways. He loved his kids, no doubt about it. And I think he loved Dee, his last wife. But this was a huge disservice. If you think about the toll that this took on the family, I mean, doubtlessly millions of dollars, but much, much more than the money. These relationships will not be repaired. And the damage to health that occurred, that intangible thing that we know exists nonetheless, you can't get that back. Those years of your life spent at war thinking about this that should have been spent thinking about better things.
Welcome to Life's Third Act, an enlightening look at estate planning, retirement, and beyond.
Welcome back to Life's Third Act. This week's episode is the conclusion of our three-part series on the life, death, and estate of Conway Twitty. Check out our previous episodes to catch the full discussion. Another decision
that was made, which was a source of conflict, was these two people, not because I think that they, I'll just call them executors. The executors chose to hire Dee as almost a consultant, a manager to help sell, identify assets, to catalog them, to assemble them in a way that they can be sold to the best avenues of marketing, whatever that might have been, whether it's in an industry or perhaps other sources. At first, you wince and you think, well, gee, of course the kids felt that that's a corrupt scenario. But it doesn't mean it was, because like it or not, and this was the judge, when the children objected, the judge's position was that this person is qualified. I mean, in the inner circle, somebody in the inner circle, someone that has a shared interest with the kids, because the more money that's yielded, it means more for everybody, because what they're getting are percentages, not fixed amounts. So let's assume the division is 30-70 between the kids and the surviving spouse. So if the surviving spouse gets more money for something, then obviously everyone benefits from that. So the kids objected. They didn't want to cooperate that scenario, and they felt that things were going to make their way off the records, and we don't know about that. I mean, certainly she was paid, so it wasn't a position where the Dee charitably gave her services. So that perhaps was cause of some of the objection, was the amount she was paid. But I suspect she was paid what would have been paid to a third party. And as to whether she used that position to her advantage, I don't know. That certainly allegations of that nature were made. It's hard to know. Again, in disputes in family matters, especially regarding personality, as opposed to things for which there's digital data like bank accounts, securities accounts, those things, you move things around like that, unless it's Bitcoin, you're going to know pretty much where it went and who got it. Whereas personal property, it just kind of walks out of the house, potentially. So both sides, I'm sure, made allegations in this area, but this was another source of conflict with the kids, was the bringing on of Dee, and their sense that Dee was more aligned with these executors than she should have been. So those legal actions all occurred in the first, say, 3 years. And then finally, there was the development about, well, what about the intellectual property assets? Now, intellectual property includes royalties, but it also would include name, image, likeness. So all those intangibles that would be collectively called intellectual property, these were things that the judge didn't want to order auction of this. I mean, it raised some legal questions, that auction, but beyond that, it would just be very inefficient, and it would just result in a bad outcome for everyone. So the judge didn't want to do that. So the judge did something else. The judge ordered that the two parties, when I say two parties, on one side are 4 kids, on the other is Dee. So the judge says, between these two sides, you all bid for the intellectual property between yourselves, but whoever bids the highest will get it. Now, I don't know how the financing was arranged where the judge could be confident that unlike with the personal property, that the children were not penalized by their lack of access to financing, to resources. I think the judge in some way, I couldn't find this in the order, but I think the judge had satisfied himself that the 4 children had access to financing to bid what they wanted to bid within reason for the value of this, and the wife too, or surviving spouse. And this is almost a Solomon-like order, because had the judge ordered a third-party sale, both would have been arguing that there was waste. Had the court assigned a value to it and divided it, both sides would have been arguing that the valuation was too high or too low. So this let them each, in effect, opine and back it up with the resources as to what they think the value is and whether they want it. So it turns out that the kids prevailed. I think it's $4.4 million is what they paid. I think it's a good price for getting access to. Now, I'm oversimplifying this a little bit, because there were a couple of different baskets of the intellectual property. This included royalties, and I'm pretty sure it also included all name, image, likeness, but there are some other forms of intellectual property that I know kind of fell outside this broad category that I'm using now. But for the most part, it represented the bulk of the things related to his hit songs that he co-wrote. He co-wrote a bunch of his hit music, I think like 21 or so of his number 1 country hit or top 10 country hits he co-wrote, if not more. So he was a writer, and that's, of course, as we know, if you watch the show, that's the source of most of the money that artists get. It's not their performance payments, but it's the payments related to the songwriting. So that resulted in more litigation before the judge finally decided that was the way he was going to solve the intellectual property. So here I hate to even venture a guess. Whatever money these kids had, and Dee as well, they had to spend a ton of it just in litigation. This stuff is not free. And generally litigation in probate court is not based upon a percentage that you recover from the other side. This isn't like personal injury law. It could be, depending on the type of the lawsuit. If you're suing related to a tort, what's called a tort, then yeah, maybe that. But this legislation or this litigation, no, I don't think so. I think that probably, I hate to even venture a guess, I would say well north of 500,000, and I would even suggest north of $1 million on each side of the table. A lot of money was spent in a lot of litigation because it went on. I mean, matter of fact, the last litigation was like in 2008, and that's still related to some of the music publishing and royalties, a lawsuit against Sony. So that's kind of a residue of the judge's original order, and the settlement of ownership that occurred in 95. So, you know, I can't tell you that if Conway had done this correctly, that there would have been no litigation, but there would have been dramatically less. Because and we'll talk about, I'll kind of summarize these points here in a little bit. But this resulted in a lot of bad feelings and stress over a period of lives, decades of each of their lives, maybe a decade. And how do you measure that toll? You can't measure it just in terms of the dollars. You could say, yeah, this cost, say, $1 million a piece in conflict. Cost is much greater than that. I mean, all the time that was spent, all the thoughts, the sleepless nights, the anxiety, the bitterness. I mean, how do you measure the toll on health and longevity? But it's real. You can't doubt that living with conflict, those of you who've been through a period of stress like that, or people you've known, and you've seen their health deteriorate. You may have seen people who died, you're convinced they died way earlier than they should have because of the stress that they had perhaps toward the end of their life relating to something. So in this case, definitely I think that we can say Conway would not have wanted it to go this way. But I also want to talk about, when I'm summarizing the way this went, is these assets. We can't fail to talk about what, in some respects, is kind of the centerpiece of the estate, not because it was the most valuable, but because it's the most well-known. I'm talking about what was called Twitty City. Yeah, so Twitty City, this was, this must have followed the creation of Dollywood because it was similar to Dollywood in some ways. And it was a kind of part amusement park, part museum. It had a compound of houses for each of the key family members. Mom had a house. I know at least 2 of the kids had a house, and maybe all 4. In other words, it was said in the reports that we read that children were living at the time of the divorce on the property. Excuse me. At the time of the death, they were living on the property. So you had residences, you had entertainment facilities, you had places for venues, for performances, concerts. This was a big property, and it cost well north of $4 million to build it. We don't know the entire cost, but the record that I have on construction costs is 3.5. So 3.5 at least. And remember, this is back around late 80s when this was being built. So that's a substantial price tag for something of this magnitude. And this is where Conway had his mansion, and he had his family there, and he has family on the payroll. And this did produce profit for a number of years, but because in the very end years, there wasn't the attention there should have been. And then when Conway dies, there's definitely not the management there and the investment, so to speak, to preserve this business. So it's not surprising that in ordering that assets be sold, ultimately, among those that the court ordered to be sold at auction, third party, was Twitty City, which I can tell you, it is in Henderson, Tennessee. Those of you who know that area, it's a very nice area. Cordell, we have an office in that area. So it's relatively affluent area, which means at the time that he bought there, it was very affordable. It wasn't what it became later. And I'm sure that the land is a marvelous investment. Now, they probably didn't get the full benefit of that selling it when they did in the mid-'90s. But the buyer of that was a religious network. Can you see who the religious network was that bought that, Justin?
TBN.
Yeah, TBN, Trinity Broadcast Network. So they bought it for just over $2 million, didn't they? 2.3. So, again, this is an example where I'm pretty confident this property did not get the value that it should have. And that is because when you sell things under conditions such as auctions relating to divorce, relating to estates and probate, when you have that creditors who foreclose on things, those sorts of sales never yield the amount that when you list something and you patiently wait for a buyer to come along that you otherwise get. And so another example of how there was a cost related to this conflict that, in my opinion, did not have to happen. How much did the estate lose out of all these examples I've talked about? I don't know. You can speculate. I can speculate. I can tell you one thing is a lot of money, and that's before we think about the attorney fees and the intangible costs that I mentioned a few moments ago. One other thing that became a big source of conflict was Conway Twitty apparently kept records relating to accounts payable. His children would get money from him that beyond what their paychecks were. And somebody kept these records. I'd be curious to know whether Conway started keeping these or whether Dee started keeping these. You can tell where my mind goes immediately. I'm thinking maybe Conway wasn't so concerned about keeping records of this, and it was really Dee that was concerned about these family members paying their way. But anyway, it could have been Conway because there are tax benefits to the extent that you have records of these not being gifts but being loans. So there could have been some tax planning, but there's no evidence of tax planning anywhere else. So, I mean, that I won't get into in this, but it was another source of waste related to this estate that could have been avoided with proper planning. So here we have this property. It's sold for the $2.4 million. We had the accounts receivables, these monies that the family apparently had borrowed over time that they were convinced were not intended to be collected. So that becomes a source of dispute. It turns out that the executors, I think they actually filed suit against two of the children. If they didn't file suit, clearly they were going to. And the children, of course, were shocked because they're thinking, wait, the executor's job is to assure that we, the beneficiaries, get the most money. And, of course, from the kid's standpoint, we were intended, in fact, to be the only beneficiaries except for this Tennessee law or this spousal election. So you can see why the kids reacted the way they did. But if you properly understand the role of the executor, remember what I described at the outset of this show is that they have to protect, they have to identify assets, they have to, and sometimes take possession of those assets if they think there's any risk to them disappearing. Their job is to preserve the estate and to maximize the estate. When you have an estate that's open, as is not uncommon for several years, and yes, as I mentioned, it can go 10, but it's not at all uncommon for an estate to be open a number of years, particularly when it's a larger estate, easily 5 years. That's not unusual. So when that happens, you don't expect the money to simply sit under a mattress somewhere or to be secured in a vault. The expectation on an executor is that they manage the money well, and that includes assuring a reasonable rate of return. So not only do they have an obligation to preserve, but they have an obligation to enhance an estate, which when you have a complicated estate, that problem becomes very difficult. And if it's a going concern, particularly one led by an individual and the fame of the individual, it becomes very difficult to preserve the value of assets, not to mention to enhance them. Sources of cash flow drop very quickly in that scenario. Same way with small businesses. So in this case, he goes to his duty is to maximize the estate. He goes to creditors, and he doesn't distinguish between creditors who are beneficiaries. So he brought this action against them, and I understand why they would feel this way. I would feel that way, especially if I felt that his attitude was one that he derived pleasure from that sort of thing. We don't know how he regarded the girls, but I would suspect, or the kids, I suspect it wasn't good. So anyway, he comes after them, and eventually he claimed north of $50,000, for example, for Kathy, I believe it was, and a substantial amount for another child. Well, thankfully they objected. They chose to litigate it. More money spent, but it turns out that a judge ultimately, and this was an appellate court. So now you see why the cash register, you just keep hearing ding, 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 ding. So to the extent that they're at the appellate court, that means they've gone to trial, a bunch of money spent at trial. Now they're appellate court. They have appellate lawyers. You wait often a year for those judgments or more. But anyway, that judgment struck it down to, I think they were under $1,000 for both kids. So I do think that perhaps there was just bad blood here with the executors, and maybe the executors discharge their duties perhaps with too much zeal when they don't prevail. And in this case, not only do you not prevail, but you choose to pick a fight with somebody who's beneficiaries. But in their defense, these were in the books. They were listed as accounts payable for whatever reason. And so these assets became, the collection of these assets produced more litigation. You should know this, there was life insurance, and the life insurance I know was over $1 million. And that went directly to D. Now, one thing you should know about life insurance is unless you name the estate as a beneficiary, which rarely is that a good idea. I mean, as a general rule, don't do that. It can result in estate tax problems and other things. Normally, an individual is named. So money that's paid out that way is not part of the estate. It goes to the individual. So another source of irritation, I know, to these kids was D had gotten this amount of money. It's north of $1 million. Was it $2 million? I'm not sure. But that wasn't in the estate, so it wasn't up for dispute. There was some investment real estate. I don't know about where that went. I know that there were some properties, so I'm sure they were sold. Twitty Enterprises was an entity that Conway operated under for a variety of different activities he did. That may not have had any what accounts call going concern value, meaning a value beyond just the individual assets themselves. In other words, it's a business. It has value beyond, just the value of the furniture and the inventory, et cetera. So I think that whatever that was, it was liquidated and not sold as an independent entity. So you have lots of forced sales here, and lots of anger and lots of litigation. What did I show as the last? Yeah, so the mid-'90s disputes the children to remove executors and contest asset distribution. Okay, that was the litigation that was going on, say, in 95 and 96. The late 90s, the court cases relating to subsidiary matters in the estate and property management. They had judgments that were published in 98 and 99, and these related to various issues. I won't even identify for them. It's enough for you to know that more litigation, and more than once to the Court of Appeals. I mean, this went, they had at least 2 different matters go to the Court of Appeals. And that means long delay and additional expense. And then I told you that some of the issues relating to intellectual property spilled into the 21st century. And so and as late as 2008, we're seeing disputes with Sony over the rights that were given to the children as part of the probate auction. So where do we go in terms of how we summarize our lessons relating to this case? Okay, so I guess the way I would wrap up this whole discussion regarding Conway Twitty and his estate planning or lack thereof, I would list as, number 1, we have the wills, like trusts, need to be updated. This seems obvious. I mean, it comes up a lot, but I don't think people appreciate the reasons, the numerous reasons why you need to revisit your estate planning, whether it's a trust or a will. Certainly, if you are going to change beneficiaries, you should. A divorce, a marriage, those things, yes, you know in that case that you need to change it. So for Conway Twitty's purposes, clearly. Also, you need to reconsider it because of executors. I mean, the executors are, I've explained to you the huge role they play, and if you're no longer have a good relationship with somebody, or you observe that this lawyer that you were going to have do this, that's a friend of the family, for example, it's not uncommon, or a lawyer that you've used in your business that you think could play this role, maybe you've not talked to them in the last 5 or 10 years, or maybe they've grown apart, maybe they've done something that you're not as impressed with them anymore. There's lots of reasons that you might want to change your executors. And also, I mentioned here changes in assets too, because what might have worked with one plan won't work with another. And when you have complex assets, which include like businesses that have to be run not only during the period of the pending of the estate while it's in probate, but also you have to transition thereafter, and those can quickly lose value in the wrong hands. So it might be, furthermore, that the distribution plan you had made sense when it was one set of assets, but now that the assets have changed, maybe they've gotten simpler. Maybe you've sold the businesses or the things that required active engagement, and now it's just passive income, CDs or something. So maybe you think, well, gee, I can reallocate these to my beneficiaries. I can make direct distributions as to some to people that I wouldn't have before. So the constitution of the assets, whatever that is, you need to think about that when you consider, gee, do I need to change what I thought made sense, what I had before? Another point I've not mentioned, I don't think I've mentioned today at all, is a prenup agreement. I'm just really a little shocked that there was no prenuptial agreement here. Now, if somebody knows of one, let me know. It didn't come up anywhere in the litigation, and I couldn't find any record of it being filed with the court. So I just can't believe, though, that somebody who going in their 3rd marriage, marrying someone substantially younger, someone with 4 kids that he loved, and I don't doubt that, he had a good relationship with his family, why you would risk what happened here, why you would take that chance when you have assets. So I just think that was reckless. And in going concern in other complex asset estates, I kind of said this already, is that you do need to come up with a very specific plan of how your assets are going to be distributed if they're of that nature. If you have an estate that consists of a business, a family business, perhaps you have some intellectual property, maybe not, but you have assets that are kind of difficult to value and they're sensitive to depreciation, things that require active engagement to preserve their value, whatever that is. Things that require special care, that expertise, that are not simply CDs in accounts or stock certificates. That should affect your plan. And in this case, there definitely could have been a very detailed, a very prescriptive plan by which these assets would be managed and ultimately distributed to the beneficiaries. That was very possible in this case. And this is apart from the idea of not updating the will. Updating the will would have fixed some of this, but it wouldn't, without more, have assured that this went off better than it did, without the chaos regarding memorabilia and whatnot, and the conflict regarding the intellectual property, and doubtlessly the devaluation that resulted in Twitty City, being poorly operated for a period of time in an effort to sell it. That could have been anticipated and better managed than just say, these are my executors, I trust them, they have good judgment, I'm going to let them manage everything. That's just a prescription for disaster. Another thing, failure to plan has generational consequences. I talked about this a few minutes ago, so I won't go into it, but the waste and the harm that resulted from this inaction. I don't want to be hard on Conway Twitty. He was a great man in many ways. He loved his kids, no doubt about it. And I think he loved Dee, his last wife. But this was a huge disservice. And if you think about the toll, I won't go into it again, but the toll that this took on the family, I mean, doubtlessly millions of dollars, but much, much more than the money. These relationships will not be repaired. And the damage to health that occurred, that intangible thing that we know exists nonetheless, that's, you can't get that back. Those years of your life spent at war thinking about this that should have been spent thinking about better things. So that kind of summarizes my thoughts regarding Conway Twitty. I hope this was helpful to you. I hope that you enjoyed it also. And I look forward to your returning again to Life's Third Act. Till next time, take care.
We hope you enjoyed Life's Third Act, sponsored by Cordell and Cordell, your advisors for estate planning and beyond. Subscribe and join us weekly for thought-provoking discussion and topics exclusively focused on estate planning and your financial future. Discover more at CordellCordell.com. The choice of a lawyer is an important decision and should not be based solely on advertisements.